G'day, Karen. How are you?
I'm pretty good. How are you?
Yeah, another week of lockdown. I can't say I'm full of beans today.
Yeah, no, I think that was me yesterday. It's a bit up and down, but I think at this moment in time, yeah, I'm all right.
I'm not sure I can cook any more interesting food. I think I've run out of the interesting food cooking thing as well.
Yeah.
I'm about to start taking takeaways again.
Okay.
Now, on the upside, I think now that we've got our playlist together as a firm for our lockdown playlist, what do you want to do with the lockdown playlist?
Yeah, there's a couple of interesting selections in there, but that probably reveals my lack of taste in music, right? But I think it would be great if we could share it with the our group here. So we won't do that. We won't do that now. We're going to get
caned if we share that.
Sorry,
we're just going to get caned if we share it.
Oh, yeah, but you don't know. There might be a couple in there that really, we might have a couple of fans. I mean,
it works for me. I listen to the playlist. And it works. I keep.
Well, Megan says yes. So if anything, but there's a couple of. I reckon there's a couple of goldies in there, if I could call it that.
Matt.
The Nutbush, yeah.
Nutbush, City Limits, and Matt.
I think it's one of those divisive songs. It's either you either love it or it just kind of brings you back to all these horrible.
Man, born in the 90s, he lives in the 70s. What's going on? Anyway, let's get on and talk about what's really happening in the world besides Nutbush City Limits. Obviously, the things that have run through our door in the last week has been about mandatory vaccination. So we've had, I think I've had about 15 to 20 calls about it. It drives me crazy as a concept, I've got to tell you. And the reason, I don't have to tell you that actually, I don't know why I use that phrase. But what I don't understand is this. 1970s, Victoria introduced mandatory seatbelts just to protect people from themselves, okay? It was adopted throughout the world because it's a good thing to stop people killing themselves. In the meat industry, it's mandatory to vaccinate, and you will be prosecuted by a regulator if you don't, a WorkSafe regulator, for Q fever, which is a disease which has a lower lethality and transmissible function than COVID. And nobody complains about these things. And yet we have a lunatic fringe who's trying to stop people being vaccinated and saying there is no disease. So I guess it's starting to really wear thin on me. When we look at the risks to business and the risks to people and the inaction of government that we've seen, it's not just our government, it's throughout the world. When you look at people who are mandating vaccination, there's some types of organisations that Greece are requiring it, Ireland's thinking about it, UK's thinking about it for aged care and health workers, Moscow is doing it for certain health workers. There's not a lot of people who are doing it, but there's just blood on the hands of the people who aren't, because legally it's quite difficult to mandate it. We'll talk about how to do that afterwards. But you'll see with SPC, who we spoke about last week, which is a fruit cannery business, that they've sought to mandate it in regional Victoria. And the union, adopting Sally Mannis's line, who's president, have said, look, if there's sufficient health evidence and you've done an appropriate risk assessment, we won't resist it. But they are resisting it, just like the ASU did when Labor governments and Liberal governments in 2 states required vaccination for aged care. And then you come to this other problem that our crazy federal government forgot to order any vaccines. So, yes, it's mandated in aged care, but there's a real problem. The level of vaccination in aged care is incredibly low. And it's got to be done by the middle of September, and there won't be sufficient vaccinations done by that time. So we're in this terrible conundrum, and SPC is an example of that conundrum because there are lower levels of dosages available in regional Victoria than in metropolitan Victoria, which means they're going to really struggle to get vaccinations of under 20s, and that's what the union's falling on, under 40s, sorry. So SPC is an unfortunate case. We would have thought by now that hospitals, healthcare facilities mandated, because they'll kill people. It's pretty easy. They are the major source of infection. So the most dangerous place to be when you're unwell is a hospital. It has the highest level of infectious disease swimming around it. And yet there is no mandating. And I don't get it. But look, that's SPC. We'll come back to mandating a little bit later and talk more about it. But I just want you to keep thinking about that. Seatbelts? Okay. Yes, thanks very much, Margaret. You're right. The number of fatalities in Sydney from Liverpool Hospital is just a great example. Seatbelts, where we're just protecting ourselves, we'll mandate them. Q fever, not transmissible human to human, low level of fatality. Regulators, and one of our clients was prosecuted for failing to vaccinate a person. Okay, that's just a disease from a cow, not a pandemic that's killing people all around the world. So it makes no sense to me. Let's move on, because that sounds like I chewed off Brad Seagrot's ear about it earlier this week. You can tell I'm a bit frustrated by it. But very new industrial manslaughter case, Queensland, who's done all of the prosecutions beside the ACT. So ACT had the case of the Queen versus Watts, which had reduced down to reckless endangerment as a plea deal. That was a crane case with an overloaded crane. Commonly, these are crane cases. The other three prosecutions for industrial manslaughter have all been in Queensland. And the most recent one, which has just started, is MSF Sugar, which again is a crane striking overhead lines. The other two cases is Brisbane Auto Recycling forklift case, $3 million fine. And then there's the one which is against the director of Owens Electrical Motor Rewinds, which hasn't been heard yet, but that's directly is against the director. I guess what all these cases have in common is there is very clear guidance that exists around what is good behaviour with cranes, good behaviour with forklifts. And as of 12 August, the Fair Work Ombudsman issued a release on mandatory vaccination and told you actually when you can and can't do it. Now, it's a fairly defensive publication, but it's come from the federal government, okay? It does say exactly what the unions say, which is with the appropriate health advice and with risk assessments, then you can proceed to vaccinate. We've got two Fair Work cases. We've got Glover and Ozcare that says if you can show that vaccination protects an inherent requirement of the job, then it's a lawful and reasonable direction. Everyone knows that who's listened to me for a while. Failure to comply with a lawful and reasonable direction allows termination of employment. And you've got Barber and Good Staff, which says that flu vaccination is mandatory in childcare. That was upheld by the Fair Work Commission as well. So we've got all the case law that says, if you consider this carefully, if you say it's an inherent requirement of the job, or it is obviously an inherent requirement of the job, and there's guidance telling you what the risk is, then you're looking down the barrel at industrial manslaughter prosecutions if you don't do it. And I think this is what hospitals and other people need to think. While they're standing there not doing it and killing people, will the officers be liable? The answer is yes, they will be, because clearly if you can be prosecuted from getting a cow disease, you can be prosecuted for letting people die from a pandemic. I've got going pretty hard today, haven't I?
You are. And Andrew, I think what I'll add to that is that, look, all the issues that you've raised there are critical safety issues. They're critical risks across the workplace. So I know that a couple of our clients that we've been helping have taken this, have been very proactive in identifying and managing those critical risks. And where you do, and you got controls it, and you can monitor that regularly, you can see the improvement, and you can get you get the confidence and the assurance, and the employees and the workforce will feel that as well, that it is safer, or it's as safe as it can be doing what we're doing. Now, there's no excuse where it's a critical risk, whether we're talking about COVID, whether we're talking about crane work or forklift work. If it's dangerous, there's no excuse. There's information guidelines out there, and there's a total expectation that you do something active to manage it.
And there's an opportunity too, isn't it? I mean, the safety law creates HSRs. It creates groups that you can talk to and actually mobilise to say, look, how do we make safety good in the organisation? And this is a chance. I
think that's something that's spoken enough about, Andrew, in terms of the HSRs, that these people, these employees are tasked, or certainly they volunteered to represent workers or their employees around advocating safety, right? So those conversations should be occurring. The engagement should be positive. They're part of the solution. So if you haven't been engaging as well as you should be, this is the time to really get that going and create some positive momentum.
And here's the opportunity to provide the health information at that level, to actually do the risk assessments at that level, so it's understood. And so it's an educative process that goes from the bottom up, rather than imposing it downwards and having the frustrations of unions saying, well, look, you're not consulting appropriately. So I think in our organisation, we've been careful to consult with everyone around it and talk about what we want. And we will have universal vaccination across our group very shortly. But that's be no need for mandatory vaccinations because of the education and discussion that has occurred. But in larger employers, there will be people who say no. And you've got to be able to say no jab, no job. You've got to be able to say it. Interestingly, I just put this up. This is our discussion on 11 April 2021 about mandatory vaccinations, which talked about what you could do and couldn't do and where the risk would be with new Delta variant. Pretty exciting. Actually, it's nice to see that we pick things. It's very good. But you can always go back there and look at the discussion around what is the law that supports it. But remember, risk assessment is the key. Fascinating case came through this week from New South Wales, which was Todd James and New South Wales Trains, where James was alleged to have done some misconduct. There was an investigation by New South Wales Trains. It found that the misconduct had occurred, and then in accordance with the legislation that governs the employment of train drivers and an enterprise agreement that further governs the terms and conditions of employees in trains, they demoted him. And for him, that was a pretty serious thing, because in 6 months' time, he knew as part of a structural review that his role was to be made redundant. And therefore, by demoting him and reducing his salary, his redundancy payout in 6 months' time would be less. And so he brought an unfair dismissal claim, and a jurisdictional argument was held. This is not appropriate for the Fair Work Commission to deal with it. Demotion is not a matter that's dealt with under the Fair Work Commission and unfair dismissal. And there's a legislative fiat that permitted it both under a separate piece of legislation and an enterprise agreement. And the Fair Work Commission have said, no, go ahead. Demotion is a form of unfair dismissal. So you can see, and I guess the reason I'm raising it is, if you're not captured under the unfair dismissal regime and you've got it as part of a contract of employment that you can be demoted, then you're going to be reasonably safe, okay? But where you're within the unfair dismissal regime, you will always have someone bringing a reinstatement application if you demote them back to their original job. And it's a pretty nasty place to be, because if they win, you've got a person in your organisation who's won an application that says you can't demote them. That's true, but they then become pretty untouchable. So an interesting piece of law, quite new law, and for that reason, quite interesting law around how the Fair Work Commission and what jurisdiction it does have, despite alternate legislation and enterprise agreements, and how demotion for anyone who's captured by unfair dismissal will always be an argument that can properly be had about unfair dismissal. So we thought we'd give it to you to see what you thought about it. And it's out there in your bag of tricks when you're trying to manage people. Demotion is not such a flash idea. Now, I'm doing a lot of talking today, so I'm going to jump into one more, Karen, before we go to you. We promised we'd talk to you a little bit about Workpac. Now, remember last week we talked about the High Court Workpac decision, and I said to you, and I'd only had a chance because it came out the day before the briefing, I said, look, it seems to me this has changed our entire jurisprudence around employment law. I think it's going to have much bigger ramifications. And what it said in relation to casual employment is it doesn't matter what the substance of someone's employment is, what they actually do. So as long as you have keywords in a contract, it is what the parties agreed to, which is the nature of the employment. So this went beyond the Morrison reforms to the Fair Work Act. This basically said, even if you're not performing like a casual, if you have a contract that says you're a casual and you have this key phrase within it, then you're definitely a casual. And the reason behind that is the court said, look, we shouldn't be acting as a quasi-legislator. We shouldn't be looking behind a contract that has been formed by parties. And as I said to you, that's a complete nonsense, because the whole industrial regime is set up to protect the unequal bargaining power between an employer who's offering a job to a person who wants a job. It doesn't have the same bargaining power. But the High Court has said they do. So Matt and I reread the case several times and did some further investigation around independent contractors. And I think it's dramatic what's going to happen. In the decision, the key decision around what is an independent contractor, which is called Varbu and Hollis, which said you look to a range of factors in substance as to whether a person is an independent contractor or an employee. And all of you have seen those contracts which says work can be assigned, sets out all the criteria, okay? We've all seen them. And you all know that the contract's almost meaningless, because if you don't treat the person that way, they're not an independent contractor. And we know the tax department also has rulings on this issue, also on the Hollis case, but it was another tax case of Hollis. And the High Court said it doesn't agree with it. Now, there are two cases coming up. There is ZG Operators and Jamisk, and there is, sorry, I'll look down, CFMEU and Personal Contractors, two independent contractor cases presently before the High Court, where this is going to be agitated. And I suspect the High Court is going to rule that Vabu and Hollis is meaningless, and we'll come back to what was the contract that existed between the parties. The Deliveroo decision is sitting in the full bench of the Fair Work Commission at the moment, and the full bench has said, look, we're not going to consider this at all until we see what the High Court says. Because, and it's got Joe Cantizani and a number of really clever commissioners who are sitting on that, deputy presidents who are sitting on it, because all of them get the feeling the world's about to change. And the world is about to change. And for us, Karen, we won't know how to craft that independent contractor till after the High Court decision is made. But what I can tell you is the contract will be clearer. It will be stronger in its capacity to characterise who is an independent contractor. And this will wipe away the confusion around the gig economy, because if what happens is what we think happens, which is they go back to what is the contract, you will be able to contractually engage someone as independent contractor when they're clearly an employee. Okay, that's what the decision will be. And for all of us who've struggled around this issue, I don't think it's good law, but it's going to be with us for 10 to 15 years. It's not an old High Court. This is a young High Court. And it's a unanimous decision of that High Court, which takes us back to the way we interpreted cases in the 19th century. That's where we are. Mm-hmm. So I think casuals, you now know that there is a specific recruitment and employment contract you must have to protect yourself, and it works because the High Court says it does. You don't need to worry about all the other stuff anymore. We think that's going to happen with independent contractors. That's pretty interesting, and we should know in the next few weeks or months as to what that is. And when you do, we'll create a guide for you so that you can utilise it, because our inability to use independent contractors for flexibility with the ebb and flow of work during a really disrupted workplace, which is the way it's going to be forever and a day. If the High Court give us that flexibility, a whole lot of the problems we had in the past disappear, don't they? Because we're not worried about everyone becoming permanent employees. We can actually deal with ebb and flow based on the use of casuals and independent contractors in a way we weren't able to do 2 months ago. So that's my piece for today, and I won't be too excited after that. I'm calming down now.
So I think, look, the majority of the employees that we represent do have a portion of their workforce as casuals. So certainly, if that's quite a lot to digest, everybody. So if in part of you want to understand in terms of like, what does that mean exactly for me, and how does that change things for me like right now, and how do I prepare for that? Best thing to do, rather than us try and talk through that right now, is just to drop us a note. So Andrew of your team, I know will be able to assist. Shall I do some talking?
Could you do some talking? I need a break.
All right, let's talk about recruitment preparedness.
I might do nutbush shitty on the side while you're doing it. But
yeah, okay, fair enough. All right, Sophie, load this one up. All right, guys, so since last week, I've just had a couple of messages around recruitment. There seems to be quite a lot of movement with roles at the moment. So it's an employee market at the moment. And there's some questions around as people are departing and taking on new opportunities, and employees are replacing these people. The question is coming up around, well, how do I make sure that I've got the right person for the job? Are there any other kind of tips and considerations that you can provide around helping us get this right? So following on the topic around employee or candidate misrepresentation, just a couple of considerations for you more generally around recruitment. I think the biggest point for me in this slide, because I've written it in such a way where there are more prompts for you than a list of things that you have to do, because I'm sure you've all got your own processes. The one question I'd ask is, what is the actual role that you're replacing or that you're wanting to create? Because what is the business case for it in terms of the business need for it? So for example, if you've got let's say an analyst role there at the moment within your team, and they've left or they're leaving, the person who's coming in, the role that you're needing to replace, is that now going to be an analyst, or is there an opportunity here to recreate or allow for that role to do more for you given the current operating environment. So with that, ties in with your position description in terms of, well, firstly, do you have one? Secondly, is it accurate and up to date, and does it reflect the needs that the business's needs? Does it meet the need now and for the foreseeable future? When I say foreseeable future, I'm not talking about years and years, because who knows what that's going to look like. But certainly when you've got that it's unlikely, or you don't, based on the information that you do know, that it's unlikely to change a great deal between now and when that next period of change is going to be. From that, it's about understanding, you need to understand the context of what that role is going to walk into as well. So for example, if you're going to be hiring, let's say, a HR manager, or you've got to replace a new HR manager, sure, all HR generalist skills, qualifications, all that stuff is kind of like, that's pretty simple stuff there. But what are they walking into? Are we talking about a period where now a workforce that was previously physically on site is now completely remote? Are we talking about there are a lot of industrial activities and it's quite disruptive and turbulent, unlike ever before? Like, there's more than just the role and the job itself. It's like, what environment are they landing in? What are the challenges that they're going to meet with immediately? And how is it you're going to prepare for that in terms of your interview and recruitment process to make sure that the person is going to succeed? So a couple of points for you. I hope they're useful and helpful. And if there's any questions that you have about any of these parts at all, look, please reach out. I'm happy to have a chat to anyone at any time. So Andrew, are you back with us?
I'm back with you. I haven't left with you. I may seem distant because Joe's told me I'm not allowed to do Nutbush Simulants. I've decided, Joe, I'm doing Rock Lobster now. But let's take that down and move on to our case study. Jeannie is the director of an autoimmune disorder care facility where clients stay during acute episodes of their illness. During the first wave of COVID, 3 clients died and 4 ended up ventilated and were seriously ill. They only have 15 beds. Jeannie consulted with the union and the HSR on mandatory vaccinations. 3 of her staff point blank refused, including Joan, who was the union delegate. Jeannie decided to follow the federal government lead and simply support vaccination with positive leave and an education process explaining the acute vulnerability of their patients, the risk to other staff, and that if they were infected, as likely they would cause death or serious illness to patients. All 3 employees who refused vaccinations laughed when they were being educated and said COVID was a conspiracy and nothing worse than a mild cold. Jeannie's OHS consultant told her this was a big mistake, stating that the risk to clients and staff was too high. Jeannie arranged for Pfizer vaccines to be available over a 3-day period and again 4 weeks later for the second dose. The 3 again refused. 4 weeks after the second job was offered, the Delta variant infected Rob, one of the 3 anti-vaccination staff. He attended work and was asymptomatic, failed to follow strict PPE protocol around patients, laughing and chatting with his face shield and mask off. Infected the 2 clients he was caring for and Joan, another vaccination objector and the shop steward, as you know. Joan died 12 days later from COVID. Both patients nearly died and were ventilated for several weeks. Now, I think that's it. We've got it on one page, so we should probably spring to the poll. So jump into the poll and off you go. There's no surprise today, mandatory vaccination is on the agenda. I tell you what, Karen, we've got well over 100 people again, and it's just fantastic the turn up. So thank you very much for tuning in, guys. We really appreciate it.
It's great. It's one of many, one of few things that we actually can really look forward to throughout the week, right? Like, this is the best way to be able to engage and connect with people.
Yeah, I do look forward to Friday a lot. It's fun, the whole preparation process with the guys and the discussion on what cases mean and the impact of those cases. You know, Tom did all the research behind the world history of what's happening around mandatory, even down to Peter Singer's views on it. Thanks, Kate. Peter Singer, who's a philosopher, his views around vaccinations. So it was great work from Tom, just terrific. I think we're getting pretty close, aren't we?
We are. We've got 77% participated, so we might give it another 5 seconds and we'll close off and we can talk about the responses. Okay, 3, 2, 1. Thanks, everyone.
Okay, look, that's great. The first question was, the facility was in Melbourne. Could Jeannie be charged with industrial manslaughter? So let's be clear. Western Australia, Northern Territory, Queensland, Victoria, okay, ACT, all have industrial manslaughter legislation. Industrial manslaughter shows you have to prove that there is a breach of duty, you have to show there is gross negligence, and you have to prove death. They're the three elements of industrial manslaughter. So let's go through it, Jeannie. Was there a breach of a duty? So reasonable practicability is the standard. Is there a hazard in COVID? Yes. What is the level of risk? It's very high. What is the method of controlling that risk? Remember, it's high because you have a particularly vulnerable client base, okay? And all the documentation has said that any autoimmune deficiency is a huge risk. So it's as high a risk. What is the control? Well, PPE alone could not be a control. So the control really has to be vaccination. She chose not to do it. So she understood in doing that she chose not to do it because she was struggling with it. Yes, Jeannie faces very real likelihood of being charged with industrial manslaughter. Okay. Could she be charged with reckless endangerment for the two clients? Now remember, the industrial manslaughter I was talking about was for the employee. What about the two clients? Well, once again, all we have to show there is that there was a risk of serious injury or death. It was a real one. And that she was careless as to what she did next with it. And here, she cared about it. She made some action, she encouraged, but she didn't do what she knew she could have done. So the answer is yes, she could be charged for reckless engagement because she was indifferent to the risk, okay? And we know that PPE alone is not sufficient. Could Rob be charged with reckless endangerment? Well, how do we go there? I'm sorry, I'm not looking at the figures. Yes, you do well. I agree. He should be charged with reckless endangerment. And yes, he could be charged with reckless endangerment for exactly because he knew of the risk. He was educated specifically on that risk and he was indifferent to it. And not only was he indifferent to it through the not failing to vaccinate, he failed to wear, despite being trained and educated, the PPE that could possibly have prevented it. Could Jeannie have enforced mandatory vaccination and prevented staff members from coming to work unless vaccinated? And again, you've said yes, and again, you're right. There is no doubt given, and if you look at the Fair Work Ombudsman stuff of 12 August, this is a particularly high-risk organisation. Mandating it would be appropriate given a proper risk assessment, and she should have. So Jeannie could have enforced it and there would have been no legal impediment to it. And the last question, as I'm racing through this, is could Rob's employment have been terminated? Absolutely yes. We don't have to even get to vaccination, do we? Because he had lawful and reasonable directions around the use of PPE. On the vaccination process, he could not be terminated because we didn't make it a lawful and reasonable direction. That's the difficulty, okay? But his failure to wear PPE in an environment which was so dangerous, unequivocally is a basis for termination of his employment. So there we go. Interesting problem today, wasn't it? Because I wanted to show you, if I had have said Q fever, you would have had, there's absolutely no doubt all of those things could have been true as well. Let's just go quickly for what's on next week. We promised this week to deal with the risks around recruitment for employers who made representations which weren't true. You know, like you come on and you'll definitely be reporting to Karen as the CEO and you find there's a dotted line report to Karen, but you actually report to the operations manager. Come on and we'll pay you bonuses, we'll do all these sort of stuff, and you get there and actually the bonuses aren't real. So we want to talk about that, but each week things keep getting in our road to do it. So next week we're definitely going to do that, and we're going to definitely deal with provisional payments for work-related mental injuries in Victoria, which I've promised now for 3 weeks, but again, Workpac and mandatory vaccination has got in our road. If there are things you want us to talk about, please let us know, okay? Because 90% of the topics we talk about actually come from you. So we'd love to hear your ideas and what you want to know. Karen, what about you?
I don't have anything. I'm just gonna chill back with some of those hits that we're going to share with everyone.
Yeah. I think Rock Lobster is a real goer, by the way.
And help you prepare some tools that will be useful to everyone else next week. So
yeah, I'm just waiting to hear from Joe about Rock Lobster. He's criticised Nutbush city limits, but he seems okay with the Rock Lobster. We might have to add that to the list.
We'll get that after everyone.
Rob Losser is fine. Well done, Joe. Okay, guys. See you later.
All right.
Lovely to catch up.
See you later. Bye now.
Bye-bye.